Welcome back. In this lecture, we take on the topic of resolution of international disputes, and particularly the private resolution of international disputes. Now, previously we talked about the role of the law. What does the law do? We said the law was essentially meant to regulate relationships. Well, one of the ways the law regulates relationships is by resolving disputes. The law provides a dispute resolution forum, a means for two parties who are engaged in a dispute to resolve their dispute peacefully. Now, there are different means for resolving disputes, different methods of doing so. There are public means and there are private means of resolving dispute. Now, in the international context, the parties will often choose to resolve their differences in a private setting, in a private forum. And we're going to talk in this lecture about why that is and what's the motivation for that. So in this lecture, we're going to look at the private means of resolving disputes. The first topic we'll look at is about dispute resolution in a business setting. How is it that businesses handle disputes? Well, the best way for a business to handle a dispute is, of course, to avoid it. And what we'll be talking about in our next section on contracts will be how do we best avoid disputes. Nevertheless, sometimes disputes arise regardless of how our best efforts to resolve them or avoid them. And so then we turn to some sort of dispute resolution scheme. Now, in the domestic context, that usually involves litigation. That is a lawsuit and a trial. Litigation in court is the dominant means of resolving disputes, or at least the first means of resolving disputes. Now, there are privatized methods that are available to help resolve disputes, and in the last 20 years, we've seen much growth in the use of private means of resolving disputes. Now, there are always two issues that have to be considered in an international business dispute. And we'll be talking about these issues both when talking about private dispute resolution as well as public dispute resolution. And the first issue is what we call choice of forum, meaning where is the case going to be heard? Where in the world is the case going to be heard? And the second issue involves choice of law. What is the law that will apply to the dispute? Now, what are these private means of dispute resolution and their public means of dispute resolution? Well, let's go ahead and give some names to it. Let's say there are three primary ways of resolving disputes, and the first is negotiation. Two or more parties sit down and negotiate a resolution of a dispute. The second would be some sort of what's known as alternate dispute resolution, abbreviated ADR, and within this grouping we would find both mediation and arbitration, and we'll explain what both of those are subsequently. And finally, litigation, lawsuits, working it out in a public forum. Let's discuss the dispute resolution methods in a little more detail. We'll start with the advantages and disadvantages of the first three types of dispute resolution methods. Start with negotiation. Now, there are advantages and disadvantages to negotiation as a dispute resolution method. The biggest advantage is that it's very inexpensive. It doesn't cost much money at all to pick up a phone, write an email, to attempt to reach an agreement. It's also completely confidential. The only parties that should be aware of the negotiation should be those parties involved in the dispute. It is time-saving. There's no lengthy procedures to follow. There's simply a matter of getting someone on the phone, sending someone an email. Not going to take much time at all. Another big advantage is that the parties, the ones that are going to be resolving the dispute, are already familiar with the dispute, with the facts at hand. There's no education of a third-party judge or arbitrator or a jury. There's no education necessary because the parties already in the dispute, the parties who are resolving the dispute, are already familiar with the nature of the dispute. What's it about? Now, of course, there are disadvantages to negotiation, and one of those is that the parties often find themselves locked into a position. Neither party is willing to compromise or to offer to compromise because of the fear that to make the offer of compromise will forever weaken their position. Compromise in negotiation, compromise in business can often be interpreted as weakness. So an offer of compromise, rather than being seen as an attempt to resolve a matter in an inexpensive and time-saving manner, instead, an offer of compromise tends to look like a weakness, an admission of weakness. It is also difficult in the negotiation aspect to comprehend the other party's position because you, as a party to the dispute, are so locked into your way of thinking, you may not understand what the other guy has to say. So those are advantages and disadvantages of negotiation as a dispute resolution method. Now, we said another type of dispute resolution is known as alternate dispute resolution, and we're going to talk about arbitration in extended detail in the next portion of the lecture. But let's talk about mediation. Now, you should recall from your introductory legal studies course that mediation involves a third-party mediator. Mediation is ultimately about getting to both sides to find a position in the middle, but using a third party to facilitate that negotiation. So one could look at it as an assisted negotiation. Now, there are advantages to mediation. First of all, it shares many of the same advantages that a negotiation would have. It is designed to make everyone happy, equally happy. In mediation terms, we describe this as a win-win scenario. It is inexpensive, relatively inexpensive to conduct a mediation. Depending on the size of the dispute, it can be as low as $500 and then, of course, go up from there. It is fairly quick. Arranging a mediation can usually be done within several weeks, and the mediation can be had with all interested parties. The mediation is also confidential. The parties will be sworn to confidentiality. The mediator will be sworn to confidentiality, and nothing that is said or done or an offer that's made in mediation can later come into evidence in a courtroom. So there's a strong confidentiality aspect to mediation. Everything is conducted in secret and in negotiations that are not open to the public at all. It is non-binding, meaning the worst that could happen in a mediation is perhaps there's some movement toward a resolution. Oftentimes, when I was practicing law, we would go to a mediation and we would mediate all day and the parties would walk away and no settlement would be reached. However, we had pushed the numbers, relative numbers, closer so that we were then able to achieve a settlement further on down the line. Even though it didn't occur at the mediation, it helped to forward the progress of our negotiation. And it's non-binding, meaning whatever the arbitrator or the mediator says is the proper amount of settlement. That has no effect on the parties. Whatever occurs at mediation does not bind those parties. Now, there are disadvantages to mediation, starting with that non-binding aspect. If a party goes into a mediation aware that there's no ultimate downside, then a party may be less inclined to freely negotiate. He has no fear of what could happen. Another disadvantage to mediation is that there's no opportunity to discover evidence. Oftentimes, contracts will call for a mediation early on before there is any evidence going back and forth. There's no means within the mediation method to discover evidence, to go through a discovery process. Therefore, oftentimes people go into a mediation without knowing fully the other side's position. It may be difficult to enforce a mediation award, even if a settlement is reached at mediation. There's no enforcement mechanism automatically. If one wants to enforce a mediation settlement, then one has to file a lawsuit. And if you got to file a lawsuit in the end, why don't you just start with the lawsuit? Finally, the disadvantage to mediation is that it requires both parties to enter into a good faith effort to settle the agreement. And if there's not a good faith effort on both parts, then the mediation becomes a waste of time and energy and a needless expense for both parties. All right, the final aspect of dispute resolution we want to talk about before we get to arbitration is litigation. And I said litigation is the process of resolving disputes through a lawsuit in a public forum. Now, litigation has a number of disadvantages. It is expensive. You cannot litigate without attorneys. If that litigation is taking place in an international arena, it's going to be very, very expensive to conduct. It's going to be time consuming. All of the rules and procedures that permit lawsuits to go forward also have time periods and time delays, and it may be very difficult to reach a agreement, a final resolved matter, because it takes so long to get to that point. A party can run out of money while litigating a lawsuit. It's inflexible, meaning the rules are the rules, and you can't change the rules to match the particulars of your particular dispute. The advantages are that a judgment, assuming that one party receives a judgment, that can be enforced in other jurisdictions, in other countries. It may be difficult to enforce, and that judgment may be subject to question by the second country's courts, but it is possible, and so there is some benefit to that. Another benefit of litigation would be that there is a public record. So future litigants, people who get in disputes down the road, can look at, well, what happened in this particular litigation? That should guide our decisions in our particular dispute. That's it for negotiation, mediation, and litigation, the advantages and disadvantages of each.